In this lesson, we're going to talk about natural law. We're going to introduce this major first topic within our subject of jurisprudence, just taking a general introduction to the subject of natural law theory before going into some of the more important details, history, and modern interpretations of natural law theory in future lessons' time. So, like I said, we're introducing the first subject of our philosophical inquiry. This is the interpretations of law as described through the lens of the natural law tradition. We're going to look at what law is in relation to this idea of morality, the necessity for a theory of natural law, as well as some of the early origins of natural law theory. And then in the next lessons, we're going to talk about the ancient origins of natural law, deriving out of some of the Platonic and Aristotelian writings, and then focus on arguably the most important period where natural law really flourishes, which is, of course, in the early medieval period of the theological doctrines of people like Augustine and Thomas Aquinas. So, the first question that could be asked and ought to be asked in the context of any conversation about not just natural law, but just the theory of law and the nature of law is the question of how law is linked to the concept of morality. Some of you might think that it is. Some of you might think that law and morality are inextricably linked together in some kind of way. And you could be correct in making that assumption. You are definitely not alone in making that assumption. And the reason for that is, in a lot of cases, you can make the argument that law regulates moral principles. Why is it the case that murder, for example, is considered to be wrong? Well, it's considered to be wrong because of its immorality. And obviously, murder is regulated by law. So you can make that connection. This is not to suggest that there is a one-to-one comparison or that law only regulates morality, but just that there is somehow potentially some kind of link that exists between the idea of moral principles and moral philosophy and the idea of law and legal theory. According to the philosopher, the legal theorist H.L.A. Hart, who we're going to get to in a lot of detail in future lessons' time, he argues that the concept of law is, or at least in the concept of law, he argues that and asks the question, how does legal obligation differ from and how is it related to moral obligation? So how are these things both interlinked and how are they different? What is the differences? What are the similarities? Now, the question that we have to ask before we respond to the question that H.L.A. Hart proposed, the question about whether or not law is linked to morality, what are the similarities and differences? The first question we have to ask in trying to tackle the answer is to think, well, what is morality? And if we're going to talk about the nature of law and its relationship with morality, then we probably ought to think about what morality is. And this is really where we start to see and derive some of the principles of the natural law. Because in the broadest sense, what we talk when we understand what morality is just an understanding about acts and omissions which are said to be right or wrong or good and bad. It's putting a value on your act and or omission. It is putting a value of a moral value. It is putting a moral value about whether or not that thing was good or bad or whether it was right or wrong. Now, morality is delineated between the descriptive and the normative. And now, what does this mean? Essentially, morality and moral philosophy have inherently within them both descriptive and normative dimensions. Now, when we talk about it as being descriptive, we say that morality is descriptive in the sense that it seeks to explain what it takes for good and bad behavior to be identified. Okay, so if I was to outline and see an action that is committed by an individual, I can then put a label onto that as to whether or not it was good or bad. If I see a murderer or I talk about somebody who has committed a murder, I can label that action as good or bad. I will often label that action as bad. And so therefore, I have put a descriptive identifier on what the morality of that particular action was, or that particular person. That person is immoral. That person is bad. It then also has normative dimensions, in the sense that this description then guides one to develop answers to how we ought to behave. So we're not just describing what an action is or isn't, whether or not an action is good or bad. We're also then saying what actions ought to be described as good or bad, how we ought to behave on the basis of our understandings and preconceptions of morality. All these ideas and the interlinking between natural law and moral philosophy and the idea of what morality ultimately is brings into the fold this idea of the natural law. When we talk about natural law theories, we note that these theories will place a certain amount of moral weight to the ideas and principles which are then further encoded within the law and the legal systems. Lawmakers and legal scholars are subjected to a set of moral values in the creation, development, and interpretation of law. And so what natural law essentially notes that the law ought to do more than just simply exist outside of the confines of morality. Natural law theory, as applied to jurisprudence, doesn't just tell us that law and morality are separate. They argue that essentially there ought to exist law within the specific confines of moral philosophy. It ought to contribute to the development of moral standards, and that this morality is that what we utilize to define what law is. So when we think about another first introductory question within jurisprudence, the question of what law is, when is a thing law? According to a natural law theory, we would say that it is law if it adheres to the moral principles and standards which are consistent with the natural law. According to Finnis, who is a more modern natural law scholar and who we will get to in future lessons' time, he broadly defines natural law as a system of law which is based on a close observation of human nature and based on values intrinsic to human nature that can be interpreted and applied to the positive development of law. This is a little bit of a wordy and convoluted description, but this is essentially what natural law theory tells us. Now, there are different variations and different influences of natural law theory, which we're going to get to in the future lessons on this particular topic. But for now, let's just finish by talking about what this definition is really telling us. It is a system of law, and that the system of law and the determination of what constitutes law is based on the close observation of human nature, and is based on values which are intrinsic to human nature. And so we have to see that there is a certain amount of objectivity here. There is an intrinsic value, moral value, which is placed on human nature, which the natural law subscribes to, and that we interpret this intrinsic value and apply those moral principles to the creation of new laws and the positive development of law in the future.